Well, hello, everyone, and good morning, and welcome back, as always, to Uncivil Law, and I hope you're having the bestest of days. We turn our attention once again to the ongoing case that is Sarah Boone in Florida. You remember Sarah Boone. She stuffed her boyfriend into a suitcase, and we are in the middle of jury selection, and we still have motions. I'm not sure what the motions we're having today are, but we have apparently more motion hearings, so I'm excited about that for whenever it starts happening. So we'll find out what motions we're asking for today. Not sure. I think it might be in relation to some of the document dumps that the defense has been putting on there. Perhaps follow-ups to yesterday relating to evidence and what evidence is not relevant from the defense relating to medical records, because the state was pretty unhappy with that, with the document dump. It's like, could you narrow this down to the relevant stuff? It's like, we'll get back to you. It's like, could you get back to us faster? So we'll see what they're going to do, but that's what's happening today. Maybe we'll see. Could be fun. Perhaps opening statements today. Cross your fingers. I don't know that I necessarily get your hopes up, but we are in the middle of jury selection. So if I were a betting man, I would think maybe tomorrow for opening statements, but depends on what the court wants to do. We'll see. We'll see how it goes, but we're getting there. It might be Monday. We'll see. Good morning, Tina. Good morning, Elena. Good morning, Angelique. Good morning, Tina Reddington, Daniela, Marco, Mismo in South Carolina, Best Carolina. We will see. Does your sarcasm ooze through, Marco? Hey. Sarah Boone is a fun and interesting character. And she apparently wants to use the fact that he was trying to escape from the suitcase as the self-defense for putting him in the suitcase, which doesn't really make sense, incidentally, because it's like, that doesn't really work. But yeah. She's like, okay, he was trying to escape from the suitcase. And if he escaped from the suitcase, he was going to beat my ass. Therefore, that's why I put him in the suitcase in the first place, or didn't rescue him from the suitcase. I don't know that doesn't seem like that works legally. Because it's, yeah. The thing is that your self-defense is now preceding the threat. I don't really think that works. The very fact of him trying to escape is the threat. I don't know, man. And also, not to put too fine a point on it, but if he had escaped, he might have some reason to be upset, for you shoving him in the suitcase in the first place. So you can't really quite invite your own error like that. Yeah, apparently, David, that's what she's going with. He stuck his fingers out of the suitcase, and that put her in fear of imminent great bodily harm. That doesn't really make sense to me, because that doesn't really make sense. Because it's a justification of preemptive action. And so, like, the reason I stuffed him in the suitcase, which caused his death, was the fear of him escaping from the suitcase. It doesn't quite work. The morning sun looks good. The morning sun is doing its morning sun thing. My mic has occasional crackle. Well, let me know if anyone else has a problem, and I don't know how I'll fix it, but Let me know. You keep hearing the mic crackle. Great. All right, we'll give that a shot. Turn it off and turn it back on again. See if that works. Let me know if that fixes it. And if that doesn't fix it, then I don't know. Check 1, 2. Check 1, 2. Okay. I think I might need to replace the audio interface. Every once in a while, it acts up. I don't know why it does, but every once in a while, it acts up. I think it's the audio interface because I'm not sure what else it could be. So I might need a new audio interface. I have the Focusrite Solo version 3. So I could either get the version 4 or I could get something else. I don't know. I just need to remember to kind of reset it every day or something. Maybe that will be the problem. Maybe that will fix it. But thanks for letting me know in any event. Oh, there's a clock. There's a clock. You think this clock is having a love relationship with fake window? I don't think it's the wire. Yeah, I don't think it's the wire because I upgraded the wire a while back to this one that's called Pig. It's called Pig Hog. It's this really heavy duty mic cable. It's meant for touring because, of all the stuff that, cables that go through touring go through. So yeah, it's this really heavy duty cable. So I don't think it's the cable. And it can't be the mic itself because the mic itself is the legendary Shure SM7B, which it just never dies. So it's not the microphone, it's not the cable. So the interface is the most logical conclusion. And then I just need to figure out a way to fix it. So yeah. Might be time for a new interface. So it's either probably the Focusrite Solo version 4, or it is the Elgato XLR interface. And I'm not sure between those two which is necessarily the better choice, but those would be the two logical choices. The Elgato has some potential software options though for clip guard and stuff like that I could potentially do. So maybe I'll get the Elgato one. I don't know. Does anyone have $160 they could lend me? I've had this interface for several years. There's no particular reason it should go bad, like ever. But, you know, yeah. We'll work on it. If you'd like to donate to my microphone fund, we do have a lovely QR code up here in the corner. You can donate to us through Ko-fi.com and help support, the technology fund. Thank you, Ellen Parker, for the gift memberships. As always, we do extensively appreciate them. By the way, I think that I've decided that the official Sarah Boone cocktail is Dr. Pepper and Kraken rum, because it's both simple and very appropriate. So if that is my vote for the official Sarah Boone cocktail. I was thinking about making it more complicated, but Sarah Boone is not the most complicated woman. So I think Dr. Pepper and Kraken rum is the official Sarah Boone cocktail. So I'm going to go to the store and buy those things. And if you'd like to go buy those things so that you can drink along at home, then, yeah. What am I drinking? At the moment, I'm just drinking Crystal Light. I'm drinking the same thing I always drink. It's, almost always. It's the peach tea, green tea flavored Crystal Light. It's one packet of Crystal Light in like 50 ounces of water. And that's what I usually drink, and I like it very much. Just get some flavoring with your water. The packet recommends one packet per 20 ounces, but I find that too strong flavor. So I do one packet per this bottle, which is, it's 1.5 liters, which is a little bit more than 48 ounces. So it's like it's less than half strength, but it's still plenty. Plus, it's a lot less expensive than soda or anything else, because Crystal Light packets are relatively cheap anyway, and I'm doing them at half strength. So that's what I usually drink. I usually drink the peach tea flavored one because it's the one I like the most. So, yeah. Yeah, the peach mango green tea. That's right. Yep, one packet for the 1.5 liters of water works great. Recommended. Theoretically 5 calories. It's a lot cheaper than soda as well, obviously. Also, it's less heavy than soda. So that's nice. So you don't have to lug it up. Plus, it's a lot less wasteful than soda. You don't have the empty cans or empty bottles. So it's healthier. It's cheaper. It's nice. Recommended. Give it a shot. It comes in other flavors if the peach mango green tea isn't for you. But I like the peach mango green tea, so. And you can carry packets with you if need be. Very true. I usually have one in my gym shorts when I go to the gym, just in case I exhaust my water bottle, so that I can make more at the gym. So, recommended there too. Am I sponsored by Crystal Light? No, but I'm open to possibilities. After watching the Crystal Light Aerobic Championships from 1988, how can you not love Crystal Light, right? How many of you have seen the Crystal Light National Aerobic Championships from 1988? It's a sight. It's a sight. You certainly have not. Oh, you're in for a treat. You're in for a treat. Hold on. It is one of the most 80 things you've ever seen in your life. You ready? You ready for this? It is painfully 80s.
Prime movie, normally scheduled at this time, will not be seen tonight, so we can bring you the following special programs.
Welcome to the 4th Annual Crystal Light National Aerobic Championship Finals, featuring regional finalists from all across the United States competing for the title of America's Best Aerobic Athlete.
We are the winners, watch us glimmer, like the sun for the champion. We're in control, body and soul. We push ourselves to the maximum. The champions, we are the champions.
Our host, the star of TV's hit comedy series Growing Pains, and honorary chairperson of the National Fitness Foundation, Alan Thicke. With two-time Olympic medalist and international sportscaster Dwight Stones. Fitness expert and star of TV's workout show, It Figures, Charlene Prickett. Plus an exciting presentation by national aerobic champions from around the world.
So anyways, Crystal Light's the best. That I think was my point there somewhere. Great. Moving on. Oh, Lord. Turning back from the 80s until 2024, we turn our attention back to Florida, where they are not hosting the National Aerobic Championships today, rather the trial of Sarah Boone.
William J. for the state.
Ma'am, good morning. Can you state your full name and date of birth for the record for me? All right, Ms. Boone is seated at counsel's table wearing a dark gray suit and a yellow blouse. She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's 5th amended reciprocal discovery exhibit list. The court has reviewed the objections and the defendant's 5th amended reciprocal discovery exhibit list. Anything else we need to address, state, before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the court's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions in limine or any case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating you to type a written.
Okay, that's what I wanted clarification on. Thank you.
But I just do want crystal clear clarification as to what we are both doing, because based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment. You did not. Okay. Madam Clerk is advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
Thank you.
Madam Court Reporter, how long do you think that would take you?
Probably a hot minute.
Is that acceptable? Can we address it at 1:30 before we
Makes it very difficult to prepare for opening statements when I don't know what I can say.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box,
I
but
understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable?
No.
Okay, well then, short of taking a break right now and having her create it, I don't know what else to tell you.
Can we finish jury selection? Mr. Henderson is going to take a minute. I guess we start at 10:30 or 11, and that's going to spill until probably late afternoon before we actually get a jury pick. Can we just agree on Friday morning starting opening statements? That gives her time, him time, me time.
State?
We have an out-of-state witness and people that are scheduled to come in, so we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir?
Hour and a half, 2 tops.
Okay.
And then we've got each juror is pause and preparatory.
Correct.
I believe we each have 10 strikes.
That's correct.
So that's going to take.
Okay. Mr. J?
I just need that ruling so that
Jesus Christ, let it go, man.
to prepare.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Court Reporter can provide a rough draft of what was ordered yesterday. And we could go over it and review it, make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions in limine. Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed. I understand your concerns of running afoul with a motion in limine. I totally understand that. But it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement was.
I don't think there's really any confusion
During Mr. Henderson's
about it. I just don't
Let
understand.
me
I don't understand.
then
It wasn't
ask
like
this
it was like
question.
super complex
Assuming
and nuanced.
we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' times until 5 o'clock today.
Okay, all right. Madam Court.
You want to try to
how
get
long
an
do you think it
opening
would take
statements
you?
today? Ambitious. I'm here for it, though. I'm definitely here for it.
Is
If
that
you want to do
acceptable?
opening statements
As
today, I'm
opposed to in
definitely here
print?
for it, 100%.
She could go back and pull back the audio from and re-review it and just provide it to us now? Okay. All right. Then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go
Okay.
from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State, or Mr. Owens?
Madam Clerk, so 30 minutes?
How long do you think? 10, 15, 20?
I just don't think there's any
great.
ambiguity.
All right, we'll be in recess till 9:45. Thank you. Yes, sir. Yes, sir.
One thing, because there was another motion filed last night,
Yes.
I think it would have some impact in opening statement, of course. So if we deal with that now, that would probably help.
You're talking about the motion to limine regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine.
And just to make it quick, Judge, I've read the motion, I've read the case law that was provided by the state, and I think it's accurate.
Okay, well, that saves me some time then, so I appreciate that. All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial?
No objection.
All right, motion's granted. All right, we'll be in a brief recess till 9:45. We're off the record. Thank you.
Okay, I don't really understand what the problem is, to be honest. So the state is objecting because they're like, well, there's no order from yesterday. Now, orders don't necessarily have to be reduced to writing. An oral order is fine. But they're like, okay, we want it in writing so that we understand exactly what we're doing here in terms of things. But I just don't understand what the ambiguity is. And the state even got its motion granted. It's like, we'd like to, as part of opening, make as part of our opening arguments based on their anticipated argument of self-defense, battered spouse. Which, like, okay. I mean, the defense has already said we're going to make this defense, right? That's the whole point. It's an affirmative defense, right? The state ultimately has to disprove it. So the state ultimately has the burden of proof to prove it was not self-defense, okay? So the state still has the burden of proof. But because it's an affirmative defense, it has to be offered initially by the defense. That's what we sometimes call the burden of production, okay? So it's this distinction. Like, who basically has to make the first foray into the argument? Who has to initiate the argument versus who has to prove the argument? And in the case of this affirmative defense, there's a disconnect because normally that's kind of, in most law, that's normally the same thing, right? If you're arguing a thing, you have to prove the thing. That makes sense, right? You're arguing the thing, you have to prove the thing. In the case of an affirmative defense, in every state except maybe Ohio, and I'd have to double check because I think maybe in Ohio, the defense has the burden of proof, but I'd have to double check. So at least in 49 states, how about that? At least in 49 states, the defense has the initial burden of making the argument, but the state has the ultimate burden of proof. So the state still has to disprove it. They have to disprove self-defense, which, I think is relatively easy in this situation. But so they're like, okay, but we'd like, as part of our argument, because we go first, we're the first ones to speak, right? We're the ones that make the initial opening argument, then the defense does their opening, and then we start calling witnesses. We want, as part of our opening, to effectively start trying to rebut their argument. And the judge says that's fine. Because, like, they've already given notice of their intent to do this, right? So you're just simply trying to disprove, as part of your opening, you're trying to disprove, or at least lay out the foundation for disproving, self-defense. You want to give out the framework that helps to disprove it, which makes logical sense. Cool, I get it. So where I'm a little bit vague on the whole thing about the orders, I'm a little bit vague on exactly what the prosecution thinks is potentially ambiguous here. What they think is potentially unclear. It's like, we don't know how to write an opening unless we know what's within the bounds or outside the bounds. But I'm not quite sure what they think is ambiguous in this domain. Because they just got the motion to, be able to argue against battered spouse. The defense can argue battered spouse as part of their opening. So, like, I'm not quite sure where they think the ambiguity lies, but okay, that's what they're doing for some reason. Yeah. Ohio might have updated it. It's possible, but yeah, it used to be distinct. So I was like, okay, well, I know that used to be the rule, but I didn't know if it still was the rule. So yeah. So we will wait. So we will wait 15 minutes today. We'll wait 15 minutes and see what's going on. So the clerk is now trying to do basically a rush transcript from yesterday, I guess, on this issue of there being some ambiguity on something. I'm not even quite sure what the ambiguity is on. Looks like the statute got amended effective in 2019 to have the burden of proof back on the prosecution. Excellent. So there you go. So Ohio now joins the rest of the country on that issue. Yeah, there you go. So Ohio is now a part of the rest of the country. Yay. Let's watch more 88 acrobatics. We could. Why don't they just tune into YouTube last night and listen to the court's order? That's actually a really good question. Yeah, why not just listen? Why if they're concerned about what they ordered, why not just listen back to it themselves? But they want it on the record. They want a written thing on the record for whatever they want it. They want it, Is this motion comparable to not allowing the FBI investigation into Karen Reed? No, there's no comparability in this situation. Could I explain a mistake of law or mistake of fact defense? Sure. In a criminal context? Sure, no problem. So I'll put this on screen so that people understand what I'm talking about. All right, so in criminal law, we have the concept of mistake of law versus mistake of fact. Mistake of law almost is never valid. Mistake of fact almost always is. Mistake of fact is just a pure mistake about the facts of a situation. So an example I always use is, suppose that there's a diner and you go into this diner and there's a spot for everyone to put their umbrellas when you go into the diner so that people aren't, trudging their wet umbrellas throughout the diner. So there's a spot everyone puts their umbrellas into when you go into the diner. So it's raining and you bring in your umbrella and you put your umbrella in this spot with everyone else's umbrellas, and then you have your meal. And then you leave and you pick up your umbrella and you leave the diner. But it's not your umbrella. It was someone else's umbrella. So are you guilty? And the answer is no. Because here, this is a mistake of fact. We're presuming, of course, that you just made a genuine mistake, right? You made a mistake of, you thought it was your umbrella. You had reason to believe it was your umbrella. You brought in an umbrella. So you had reason to believe it was your umbrella, and you just simply made a mistake, one for one, right? Another, you got the wrong coat at the coat check. You got the wrong whatever, right? But you had reason to believe it was yours. It looked a lot like yours. You thought it was yours. You just made a pure mistake of fact. So that's an example of mistake of fact, mistake of the thing, versus I didn't know what the law it was. Mistake of law is I didn't know the law. I didn't know it was illegal to do X. Right? So here, like, you're not arguing, I didn't know it was illegal to steal, right? That would be mistake of law. I didn't know it was illegal to steal. That would be mistake of law. You're arguing, I didn't know that it wasn't my umbrella. Mistake of fact. You were confused about an essential fact. And so that's the example. And in more older days, this also used to be a thing with cars, especially like American cars, because some of those American cars, there were not that many ways to cut the key. And cars have a tendency of kind of looking alike, as you would expect, because they're all the same make or model. So, occasionally it would happen. This is, of course, before computer controlled keys and stuff like this, but it would definitely be a thing where someone would accidentally drive off with the wrong car. And so is that Grand Theft Auto? No, it's not, because, well, they thought it was their car. It looked the same. Their key worked, which wasn't that unlikely in some situations, particularly depending on the make and manufacturer of the automobile. Some of those were a little bit loose in their tolerances. And so as the key got used, it would get slightly worn. And it would actually work on more and more cars because the tolerances were pretty loose. So people would sometimes drive off with the wrong car. Overt action. Okay, $5 regarding yesterday's hearing. Overt action was his hands coming out. The question, how was he supposed to get out? That's a really good question. Yeah, I don't really buy this as the overt act. It doesn't make any sense, because her stuffing him into the suitcase preceded, obviously, him trying to escape from the suitcase, right? So what exactly is the self-defense here? What exactly is the self-defense? Well, it can't be putting him into the suitcase in the first place. And then if it's not him, if putting him into, because that doesn't make sense, right? If him trying to escape from the suitcase is the impetus, then putting him into the suitcase precedes that. So putting him into the suitcase can't be the self-defense. If putting him into the suitcase is not the self-defense, then obviously he has the right to escape the suitcase. Right? He has the right to escape the suitcase because he's being imprisoned in the suitcase. So if he has the right to escape from the suitcase, which obviously he does, then how can him escaping from the suitcase or trying to escape from the suitcase now be the self-defense? Right? You're trying to lift it by its own bootstraps. It doesn't really work. It's like, oh, he was going to be really mad. I was like, yeah, probably. But you can't really lift the thing by its own bootstraps. It doesn't really quite make sense. Yeah. Yeah, so putting him into the suitcase can't be the thing. It has to be the force then applied to the suitcase and refuses to let him out, which makes no sense, right? Because he has the right to leave the suitcase, right? If putting him into the suitcase isn't the thing, he has the right to leave the suitcase. But if he leaves the suitcase, he's going to be really mad at me. Wait a second, though. But he has the right to leave the suitcase. And this is okay. No, this makes sense. I don't really even think that. I strongly am of the view that I don't even think that the self-defense argument should be allowed. I don't even think that it's, as we would say, legally cognizable. Ooh, fancy words. Right? I don't even think the defense is legally cognizable because it doesn't make any sense. So I'm not even sure the defense should be allowed, to be honest. But that's me. Right? It has to make some sense. It has to make some sense on some level. But it doesn't really make sense. I don't know how long the trial is going to be. I think it's going to be a while. I think it's going to be a couple. I'm not sure how long they said the trial is going to be, but I would imagine it's going to take a little time. Yeah, every kidnapper could use this defense. That's what I'm saying. Right. This is exactly right. Every kidnapper could use this defense, which makes no sense because kidnapping itself is considered a grievous harm, right? Kidnapping itself is considered a grievous harm. If you're trying to kidnap me, I have the right to use deadly force, right? You can use, right? Let's go through our basic self-defense 101. When can you use deadly force in self-defense? When can you use deadly force in self-defense? You can use deadly force anytime there is an imminent or ongoing threat of death or grievous bodily harm. Kidnapping works. Kidnapping works. So if you're trying to kidnap me, I have the right to kill you. Right? So, because you're trying to kidnap me. So, it's like, oh, the reason, yeah, I was trying to, so it doesn't really work. It's like, oh, I was trying to kidnap him. And if he escaped from the kidnapping, he might have tried to hurt me. Well, yeah. Right? It's like, I should be entitled to a safe work environment as a kidnapper. I'm entitled to, where's OSHA? Where's OSHA for my kidnapping plot? The kidnapping victims are trying to escape and they might try to kill me. Yeah, they very well might. Maybe you shouldn't do the kidnapping then. So this is Florida. I live here. The outcome of this trial could be anything. Fair. Yeah. Yeah, exactly. Safe work environment. This is what I'm saying. You know, as a kidnapper, I do kidnappings all the time. And let me tell you what, we need greater safety in my work environment. I like to kidnap people and I do it for the money. You know, it's my way of getting my income to support my family. And wouldn't you know it, these pesky kidnap victims, they keep trying to escape from my bedroom closet. And sometimes they're violent against me. Please help me, government. You know, it doesn't quite work. It doesn't quite work. If you try to kidnap me, I may try to kill you. That is just a please stop trying to kidnap me moment. So if he has the right, so if he gets into the suitcase in the first place as part of the self-defense, then okay, I guess, right? So if the initial getting him into the suitcase, was part of the self-defense, then okay, I guess. But if it's not, if getting him into the suitcase in the first place is not part of the self-defense, then you have no legal basis to hold him there. Right? He has the right to leave the suitcase. And he might be really mad and he might try to beat me. First of all, if you're trying to lock him into a suitcase, you know, he might be violent towards you. And perhaps justifiably so at that point, because arguably you're committing kidnapping now. And now he probably has the right to use lethal self-defense. So if we could view what she did as a kidnapping, which, you know, she is refusing to allow him to leave, right? She's holding him in a place and refusing to allow him to leave without cause, which sounds suspiciously like it might be kidnapping. So if he does get out and then he kills you, that might be self-defense from him now. So yeah, he might in fact try to kill you. But you can't use the fact that the victim might fight back as a basis to keep him in the confinement. That doesn't make any sense. Kidnapping or false imprisonment depends on the statute. Depends on how the statute defines kidnapping and or false imprisonment. So that's why I sort of qualified my remarks a little bit. It's like it might be kidnapping. There's a reason I qualified my remarks, because I have to go look at the particulars of state law. Some states define kidnapping in some way, sometimes they define it a different way. Some states don't even have false imprisonment as a crime. So it's like, well, without looking up the particularities of Florida law, I'll just simply say it might be kidnapping and call it a day. Yeah. In the video where he's asking to leave, he asked her nicely. There's no let me out or I'll kill you. Which, even if he had said that, I'm not sure it's legally a problem. But yeah. So I think the self-defense is trash. So I would be strongly, as a judge, I would be strongly inclined to disallow the defense. As a judge, I'd be strongly inclined to disallow the defense. I'm not saying I would disincline it. I'm just saying I'm strongly inclined to I'm strongly inclined to not allow it, because it's not legally cognizable. It's an affront. Guess who's back? Back again. Shady's back. Tell a friend. Guess who's back? Guess who's back? Guess who's back? Na 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 na. Da 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 da. Putting aside the legal problem, which I think is pretty serious, of course, you also have to convince a jury of this bullshit, which I don't know how that works. The only way this even kind of works is she's going to have to play the I'm just a girl card, which always pisses me off. I'm just an innocent girl. Tee-hee. I'm just an innocent girl. She's to do the bat the eyes and, you know, the whole shtick. I'm like, no. The fact that she's playing the I'm a victim of domestic violence card is already pissing me off, to be honest. It's like, no, you're an adult. You're an adult. Men and women are equal now, remember? So, no. I don't think if the genders were reversed, anyone would be even tolerating this for 1 second.
2603, State of Florida versus Sarah Boone.
I mean,
we get appearances for the state.
Can you imagine just for 1 second if everything was reversed except for the sexes of the people involved? And some guy was trying to argue this. Yeah, I locked my girlfriend in the suitcase, and then she was going to she tried to escape, and I was afraid for my life, and so I left her suffocate to death. How well do you think that argument's going to work? Right, not very well. So why should it work for her just because she's a woman? It shouldn't. It's some bullshit.
Well, that cures itself. Counselor? Thank you. Record reflect that Mr. Beck has just entered the courtroom. All right, the court's had the opportunity to review the excerpts from the motion in limine hearing from yesterday, and my understanding is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate?
Yes.
Okay. The court's reviewed it. Are there any questions with regards to the court's rulings on that motion?
Yes, Your Honor.
Yes, sir.
My understanding is that based on
Sure.
I like the lavender shirt, I have to say. I do like the lavender shirt. I think it looks
Madam Clerk's
snazzy.
providing you a printed copy, sir. Bless you. Have you had the opportunity to review that excerpt yet, Mr. Owens? All right, go ahead and take a look at it.
Thank you for the 500 of you tuning in on Facebook. And thank you for those of you tuning in on Twitch and Twitter as well. Appreciate you all tuning in and spending some time with me. Hope you're learning something about law. And also learning something about the stupid.
Okay. All right, Mr. J, you may proceed.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from, there were several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion, though. But paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida First DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page. Florida 4th DCA, 1971. Reed, R-E-I-D versus State, 213 Southern 3rd, 1110 at page 1111. Florida 5th DCA, 2017. Rudin versus State, 182 Southern 3rd, 724 at page 726. Florida 1st DCA, 2015. So what we were asking for is, in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid, was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled "Be Battered Spouse Syndrome Evidence," but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Thank you. Response.
I just have one question as to what time. Are we talking about or dire? Are we talking about opening statement? At what time are we talking about?
During the testimony in the trial.
That was my takeaway.
Okay. He's absolutely correct.
Okay, then the motion's granted. So the court's going to rely on that specific excerpt in Holland, 916-7-2-750, at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.4041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted.
Judge, just my understanding, I'm clear on the record. It's just procedurally correct. Procedurally, before we can put evidence of that, there has to be a claim of self-defense. That has to come from someone, and in this case, we all know that has to come from the judge.
Okay, received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that we beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday, at some point, for the record, for the 6 DCA.
Okay.
Yes, ma'am.
All right, thank you. Anything further from the state before we proceed with the objections? Defense.
Judge, yes. Just my overall understanding is that the motions and the orders that the court has submitted apply to trial and the organization or the flow of the evidence at trial. Certain things have to be presented before certain witnesses can testify. It has nothing to do with or dire nor opening statement.
That is correct, and the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right, thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today.
Good answer.
Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that Fifth Amended Reciprocal Discovery Exhibit List filed by the defense, I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to, provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume?
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
All right. Regarding item number 1 on the Fifth Amended Reciprocal Discovery Exhibit List from the defendant, I do not believe we have received those records.
Response from the defense.
You're referring to 1A1?
We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
Did defense has not received those records.
Okay. Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not base numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by...
I'm not talking about 2. You don't object to 2. Talk about 3?
Well, I do need to talk about 2 now because
Okay.
This morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Ms. Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
Okay. At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Judge, referring to our paragraph 2 in the defense fifth amendment discovery exhibit list.
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time.
Judge, the 81 pages that...
The 81 pages are not at issue.
I understand. They were given Sarah Boone from the Advent Health report. The 119 pages, my understanding is we thought we had sent them previously. We realized yesterday or last month that we had not sent them. So we provided those to the state as soon as we were aware that we had not given them.
And what do the 119 pages evidence?
They're medical records from the hospital relating to Sarah Boone over a period of time. So obviously, that's going to be whittled down depending on her testimony and whether or not it would cooperate. Her testimony that she suffered an injury at the hands of Jorge Torres.
I need more specifics than that. I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured, which would coincide with the...
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether...
So it's a discovery violation hearing. So the state is objecting on a discovery violation and saying that this does not meet the discovery standards. They dumped it on us without sufficient notice of what it is. So I thought it was a relevancy. I thought they were doing a relevancy hearing, but the judge just corrected me. It's not relevancy. It's a discovery violation. Ooh. Okay. All right. Yeah. So basically the defense just dumped a bunch of shit. Long story short, the defense just dumped a bunch of shit on the state without telling the state anything about what it is. And the state's pissed because they're like, we don't know what this stuff is. And so it sounds like the defense is about to get scolded. The tone of this sounds suspiciously like the defense is about to get whacked on the ass. Let's see if that's true.
Or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things? Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the three prongs that I need to address.
Yeah. The defense team's in trouble. Defense team's in trouble. I think they're about to get scolded, people. I think the defense team is about to get scolded. May potentially have some of their evidence excluded on discovery violations. Ouch.
Judge, my understanding is the first 81 pages were medical records of Sarah Boone that we'd gotten from one of the previous lawyers that we had sent to the state.
Right about now, I'm really happy I did not take on this case. I'll have to tell you that. Right about now, I'm really glad that I'm not standing at defense counsel table. Because I'd be getting my teeth.
When did you
absolutely
receive
kicked
them
in.
last week?
I'm not sure, Judge. I have to get my secretary. We have to take a break and let me find out from my secretary when we receive it.
Okay. I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what.
My staff is
Understood.
texting her.
All right. I'll make a note to circle back to this issue.
Okay.
Moving to
You got a stay of execution.
number 3.
Yeah. Oof.
Is this the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages that those,
Yes,
the BAC and the narrative are on?
that's what's going to be offered into evidence at this point in time.
Judge, we'll work on that right now.
Appreciate it.
I've got staff here in the
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize, you're correct. Or certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them?
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense.
Judge, we have not yet received those records. We had Sarah Boone sign a medical release, and we have sent requests to the various medical facilities asking for records, and we're just waiting on a response.
The objection sustained. Moving to 6. Certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages of jail records regarding Ms. Boone. Once again, I had to spend my personal time reviewing these records. Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years. The state just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225 goes through alcohol abuse, yes, type, spirits, not wine. Last used 223:20, several times a week. The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed, there's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant, and it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results, and we struggle to see the relevance, Judge.
Thank you. Response?
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that yesterday. That's not germane to the issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pre-existing. Now, that's not what their expert, Dr. Werner, opined in her deposition, that the anxiety she may be suffering from at the jail was from being in the jail. So there are questions about that, but generally you get these records, as you know, when you have a forensic psychologist that's trying to evaluate a patient.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant?
I'm trying to tell you.
What specifically is relevant? What page? What date? What document? You're not answering my question, counselor.
No, you're not.
They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
I don't intend on introducing these exhibits, this exhibit into evidence. I intend on potentially the doctors, the experts, Dr. Werner, Dr. Harper, to rely on these records.
Judge is getting irritated.
Of all three doctors.
Judge is getting irritated.
Date their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If she has not reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited costs for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post-deposition, post-evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. And then we took her deposition either the 1st or the 2nd. So this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence. Because, of course, experts can rely on inadmissible evidence if within the course of that area of expertise it's the type of evidence that's routinely relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. The state didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. And we would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens?
Judge, I don't want to delay the trial. I'll wait. I will not have Dr. Harper review.
So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we're going to take another deposition. So I'll wait. I will not ask her to review these.
Okay. State with...
That was the only purpose.
Okay. So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
Yes, sir.
All right. Then based on counsel's representation, the court's not going to sustain or overrule the objection, as the defense has identified they are not going to be seeking any of these 382 pages into evidence. Moving now to 8,
Ouch.
9,
So it's moot.
10,
Nice.
and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence in itself, but the reports can be used to refresh the officer's memory if needed during their testimony.
Okay. Does that cure that understanding?
Yes, sir.
Okay, all right. So based on Mr. Owens' representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence.
As moot. Yeah.
Moving to Exhibit 17.
That's probably wise for the defense. Basically, I think the defense knows what's up, and probably is making a pretty good decision. Incidentally, but yeah, the judge is like, okay, I'm neither sustaining nor overruling the objection because now it's moot because the defense isn't even proposing to offer it at all. So the defense has made a very tactical concession, which yeah. So I was like, well. Thanks for basically withdrawing the request to offer it in the first place, that you don't have to get ruled against. Holy shit. Man, it's going great.
No, I'm sorry. 16. 16 is a repeated of 11, so the court's going to adopt its, or similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing? Okay, so court's same ruling with regard to Exhibit 16 as with 9,
Moot.
10, and 11.
Moot.
Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
No, Your Honor.
Response?
The defendant is not intending to introduce the jail call.
Okay, the objection is sustained. 18,
Defense
prior
loses.
criminal history of George Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously, we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about the prior interactions with the state attorney's office.
Okay. Response, Mr. Owens.
Judge, we're referring to the prior record involving Sarah.
Sarah, right about now would probably be a really good time to reconsider that plea deal, assuming the state is still willing to offer it.
I know we had some priors in.
There have been, a lot of last second plea deals or settlements. The courthouse step
I'm
settlement
just trying to understand.
is very
are they
real.
Seeking to introduce some sort
The
of
courthouse
paper,
step
or is
settlements
this
are very,
just
very
a
real.
broad notification that Ms. Boone
So it's like, if you'd like to reconsider that
testifying
plea,
about
now would be a really good
any prior
time.
incident of violence that she wants to.
Maybe you should take the
regarding
plea.
decedent, 'cause you can't rebut it.
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion. Because if it's oral testimony, that may be a different critter once the overt act is established under Holland.
Judge, she's going to testify to it, and then it kind of ties into
The plea deal would include time served, yes. So she'd be effectively, if she took the deal, she'd be effectively out in 6 years. Yeah. If she took the deal, she'd be effectively out in 6 years. It's a pretty good deal
the nature of this.
at this point.
I think there is going to be anything about prior criminal history other than what she's testifying to.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
When's the cut to take the plea? There's no particular cut. It's whenever the state is willing to offer it or not. I don't even know if it's still on the table or not. So there's
J?
no particular
I
cut.
don't know that
You can have a plea.
papers generated by a government.
You can have a
agency
plea right up to the moment the jury returns a verdict, man.
and the disposition of the papers that
The jury could return a verdict and you could have a plea. It just depends on what the parties are willing to agree to, man.
if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or
Yeah.
police reports.
Yeah, the offer was
or
15
state
years.
Attorney records of no bills.
The offer was 15 years.
I don't know
She's
what-
already served
based
4
on
and
his last
change.
statement, I don't know what
5
we're
years.
talking about now, but we do have.
She'd
hearsay
get good credit
objections to-
time.
I thought we were talking about
She'd
physical
be out in
exhibits, and
5 or 6
that's
years.
what our objection would be to believing that what was represented was a criminal rap sheet.
Judge, part of battered spouse.
Can a judge deny a plea deal? Yes.
I assume Dr. Harmon will testify about it, Dr. Warren will testify. Is
Yes, a judge can deny a plea deal. It's very rare for it to happen, but it can happen, yes.
that she has nowhere to turn. His family can't help her, she has no group. The state attorney dropped 3 of the charges. 3 separate times George Torres was arrested, charged with violence against Sarah Boone. And her request, she wanted them dropped. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had let her down.
What determines if the plea is removed? A plea is a settlement.
She felt helpless.
A plea is a settlement. So what determines whether the plea is removed is whether or not the parties are willing.
As to whether or not she felt an imminent threat.
What determines whether or not the plea is removed is the grace of the parties to agree. That is it. That is all there is.
The state attorney's office was not prosecuting George Torres when she was the.
But that all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the exhibits? Tangible, physical.
We may want to introduce something in
Yep.
indicating that the state attorney dismissed the.
I've said it many times before.
What does that
Eddie,
have
I've
to do
said
with
it.
prior criminal
I have
history?
said it many, many times before. Many times before. It doesn't matter what field of law you practice. It does not matter what field of law you practice. The one universal rule. The one universal rule. Rule number 1, don't piss off the judge. Yeah.
History, because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list.
Judges are minor demigods. And the sooner that you recognize that, the happier you will be. Yeah.
Okay, all right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff's Office investigative workup report. Response.
That's to be used to refresh the officer's memory if need be during their testimony.
Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay. So accepted. Your objection's overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong, I color-coded this and I miscolor-coded this one.
We don't intend to introduce anything on 20.
Okay, then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because we kind of addressed this as well with number 19. Anything further, argument state. Anything further, argument? Okay, I'm going to overrule the objection as to as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence.
I don't know how. I really just don't know how you use him trying to escape from the suitcase as the overt act. That just seems like that's what they're going with. Oh, if he had escaped, we all know what would have happened. what the fuck? It's like,
Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-O. I understand the state's objection as to relevance and hearsay. Response?
Judge Brian Boone, we anticipate is going to testify before the state. When he testifies,
how are you going to sell the jury on this
witness or
idea is beyond me.
to establish either bias on his part based on some of the documents or orders in the court record or oral may reflect
Do I have a better theory of defense?
the fact that he has not complied with some of the
Accident was better,
and that he, the reason being
marginally.
his feelings for the defendant
Accident is better marginally.
son and has had full custody for 4.5 years. That was not the agreement they originally had, and he was ordered to pay alimony, which he has failed to do as a result of being incarcerated. So there's litigation going on. Brian Boone has counsel, Sarah Boone does not, and that divorce, but
What does
There are not a lot of great
what does the
options here.
non-payment of alimony have to do with what's happening in a family case?
well, that, Judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached, that her in the position that she's in now, he's biased, and to show that he's biased, that he has not paid alimony for, he's supposed to pay $1,000 a month for a number of years, that he's just failed to comply with the court's order. That shows his personal bias or feelings towards it.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge on Ninth Circuit Family Division.
Although to be
Certainly
fair,
understand why one
to be fair, it would be really difficult to go all the way from murder to nothing on an accident theory, right? Because you're basically attacking the mental state requirement, but you're basically trying to steer into a manslaughter, but the state's already offering that anyway. So accident to get yourself to manslaughter is easier, I suppose. And by easier, I mean not easy, just easier. But the state's already offering that anyway. Trying to use accident to get yourself all the way to how about I walk free is a big ask. So, but then again, it's still probably marginally easier to do accident to how about I go free than self-defense to how about I go free. So if I want to try to get out of this thing completely, if I want to escape from the suitcase of prison, I don't really have any great options, but accident is slightly easier and slightly more plausible than self-defense. This is all a whoopsies. It is slightly more palatable than self-defense. So, yeah. I mean, I wouldn't expect the jury to buy that either. But at least it's like, well, slightly better. Yeah.
One may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. And it sounds like it's all
The video does not help.
Are there any orders from the court in that case addressing?
Yeah, the video does not help either theory. The video really does not help either theory. Sarah. Shh. Yeah. Yep, that's a problem.
the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached. to
That's the
contract.
problem.
Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given
That manslaughter plea deal's looking real good, I have to say, as the defense.
Is
That manslaughter deal's
so if there's
looking
no
real good.
order in the court file finding
Real good.
there's a violation of an order to pay alimony, what is...
Well, there's a final order about his obligation to pay alimony, and I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into, under cross-examination.
But it sounds like there's pending litigation.
I swear in the name of all that's holy, if we're using the idea, even assuming, if we're using the idea that he wasn't paying alimony as he deserved to die, which sounds suspiciously like what the defense is trying to do, I am going to lose my shit. If we're trying to use the fact that he wasn't paying alimony as a basis for he's an abuser, self-defense, he deserved to die, I am going to lose my shit. That sounds suspiciously like what we're trying to do. Holy shit.
Including a relocation and I don't know because that's not my case and I
That's
haven't
been
looked at
decided.
it.
That's been decided. He has been able to relocate. I don't know all the ramifications. I'll look at the clerk file. I think we had subpoenaed the custodian of the records of the clerk file. I'll look at it and I'll let the court know and state no.
Can you all approach this for a moment?
Brian, we're talking about the ex-husband. How does that have anything to do with anything? Yeah, okay, so now I'm even more confused. If we're talking about Brian, then how's that have anything to do whether or not Brian was or was not paying alimony, or does not want to pay alimony? How does that have anything to do with anything? I mean, I don't know whether or not Brian does or should not pay. How does that have anything to do with anything? I don't know. They're talking about how Brian Boone is biased because he's fighting alimony. Okay. All right. All right. All right. Fine. So they want to use the fact that he's fighting alimony to impeach his character on the stand. Okay. Well, that makes a little bit more sense, I guess. That makes a bit more sense, I guess. Yeah. Thank you for the 800 of you currently watching, by the way. I'm very happy to have you with me. Just want to say thank you very much for spending a little time with me as we try to learn a little bit more about this case and a little bit more about the legal posture of this case. Just want to kindly ask you, if you haven't done so already, would you please consider hitting that subscribe button? I'd really appreciate it. I try to bring you some really good quality content and good legal education, plus some humor and snark, and occasionally derision at the stupid. So I appreciate it if you'd hit that subscribe button and help this channel continue to grow. Thank you very much for spending some time with me. Skip ahead a little bit. Skip. Skip.
Overrule the objection at this time. Clarifications based on the court's going to overrule the objection at this time for the reasons discussed at sidebar. Moving now to 23, the policies and procedures of the Orange County Sheriff's Office regarding Miranda. Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
What is it now that you're doing?
Introduce those.
Sheriff's Office regarding Miranda. Moving now to 23, the policy.
Oh, they're not even trying to argue Miranda anymore. Wow. So that whole big issue, right? Oh my God. Oh my God, people. The sheriff's office may not have necessarily followed its policies on Miranda because they didn't read the question. And the defense is like, we're not going to bring it up anymore. We're not bringing it up at trial. We're not bringing up that Miranda issue anymore. We don't care. It's fine. It's all good. Get wrecked. Holy shit. Oh, man.
The Orange County Sheriff's Office regarding Miranda. Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay.
Wow.
All right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action.
Yeah, I'm not surprised, incidentally, they don't want to argue it for the jury because it's such a minor, it's such a minor thing to try to attack on. It's like, I think that's the right call. I think it's the right call not to bring it before the jury because it's like, oh, they didn't ask her this one question. Isn't that really, really bad, people? It's like, yeah, I don't think that's the right ground to fight on. So I think the defense's decision here is tactically wise, but it is still hilarious.
Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay. Based on counsel's representation of not seeking to utilize it, court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay. All right. Thank you.
Ooh, defense
27.
Defense taking a lot of L's
The video
today.
footage of the arrest on
Defense is
February
taking a
25,
lot of L's
2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
State, you have such an item in your possession? News footage?
No? Not that I know of.
All right, but we have not received it, so we don't have the evidence.
Okay, all right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name. Not going to read it, it's very long.
Judge, I do not intend to introduce 29.
Okay. Court takes no action based on counsel's representation. Moving to 32, iPhone photo. Yeah, I'm sorry, sir.
29, what is the ruling?
There is none, as the defense has advised they are not seeking to enter it into evidence. 32, another iPhone photo file name. It's very long, so I'm not going to read it.
Defense does not intend to introduce.
Okay. As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG underscore embedded underscore 1 underscore 772.
We would stipulate.
All right, the objection is sustained based on stipulation. Moving to 59 and 60. I understand your objection, State. Any response?
Any and all exhibits previously listed by the state?
Mm-hmm. Yes, sir.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified. He's filed this motion in limine to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And so tactically, he was able to get us to that posture, so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And the state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that. But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder.
Really?
So,
you're not sure about
in
that?
an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day. And
That much
that's
is
why
true.
we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes to directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Yes, sir. Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion to eliminate. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion, and that if that is the proffered testimony, that is not going to amount to an overt act, which will allow for
Yeah, that's what I would say.
reputation evidence.
That's what I agree with the state. I don't think that this defense should be offered. I don't think this defense should be allowed. I don't think that him trying to escape from the suitcase can be the overt act. That doesn't make any logical sense. He has every right to try to escape from the suitcase. It can't possibly be the overt act. It doesn't make any sense. I don't think the defense should be legally offered either. So I'm kind of with the state on this one. And like the defense should be excluded. It is not, as we say in the trade, legally cognizable. And she apparently is trying to use a baseball bat as he's trying to get out of the suitcase. She's using a baseball bat to whack at his fingers to prevent him from doing it. So that would be, yeah, that's the thing. And in which case he then expires. So that's reckless conduct that causes death. So that sounds like a murder charge, right? Because that's pretty reckless, if not intentional. So, yeah, I mean that makes sense. Yeah.
Past incidents of violence, or the battered spouse syndrome evidence. They weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do, and we're making every effort to make sure that we understand how this trial is going to go down and how and Ms. Boone understands how the trial is going to go down, because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day, and right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony, unless there is. Then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence.
I think you're right.
I just want everybody to be clear and on the same page about that.
I think you're right.
Now, in regards to their request, a renewed request for a statement of particulars,
No,
they've had the discovery
I mean,
for several years.
that makes total logical sense. I'm with the state on this one. That makes total logical sense. So according to the defense, right, we're having fun. He gets in the suitcase voluntarily. You know, it's all fun and games. And then at some point he tries to leave. And then Sarah decides that she's not going to let him. And she uses force to prevent him from leaving. At which point she's committing a forcible felony as he's trying to escape. And so take your pick between felony murder, reckless murder, intentional murder. It's like, take your pick of which of these many lanes do you like best, right? At this point, is it a death that occurs in the furtherance of a felony, so it's felony murder? Is it depraved recklessness, evincing a lack of care that puts a person in a situation that causes their death? Is it I was trying to kill them, so it's intentional murder? You know, which of these options do you like best at this point? Take your pick. And yeah, I was like, so one of those things, Your Honor, would be basically our theory of the case. And she's going to try to say this is the overt act, and we're like, no, it's not. That's some bullshit. And so once she says the bullshit, we're going to object and we're going to say that she can't be allowed to offer the defense because there's no overt act. There's no overt act because the only overt act is him trying to escape from the suitcase, which he had the right to try to do. Because she didn't put him in the suitcase in the first place as it being self-defense. If somehow putting him in the suitcase in the first place was the self-defense, then I guess fine, but that's not what they're arguing. So since putting him in the suitcase in the first place wasn't the self-defense, him trying to escape from the suitcase can't possibly be like a invalid or criminal or threatening act in and of itself. And then like the only threat now becomes from her trying to prevent him from escaping the suitcase. So now she's trying to bootstrap it, right? She's trying to use the very fact of trying to prevent him from escaping the suitcase as the basis for the fear that he would harm her. It's like you can't argue that. It's like you can't argue the very fact of him trying to escape from the suitcase is now the threat. You're trying to bootstrap this thing, Sarah. You deserve to go to jail forever, Sarah. You're a horrible, horrible person.
This is the state's case. A video that starts at 11:12:45.
Hold on.
p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby, seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not, she let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical exam
I'm muted for some reason. Sorry. Just a whoopsie daisy. And it's just, just a little whoopsie daisy. And I didn't know. And it's all my bad. And, all the rest of it. So, yeah. This is some bullshit. This is some absolute bullshit. Yeah, this is some bullshit. Sorry about that. My bad. Sorry about the muted thing. Sorry. I need a new audio interface. I'm going to buy one on Amazon. I'm sorry.
Examiner comes in and says, Jorge Torres died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have...
All right, so since you missed the entire rant, I'll just do the entire rant again, or at least I'll try to. Right? The state's theory of the case makes total sense. It's like, okay, so it's like, you want a bill of particulars? Here's our bill of particulars. Here's our theory of the case. We will just tell you what our theory of the case is. You want a bill of particulars? Here's your goddamn bill of particulars. All right, here it is. Okay. We think that Sarah Boone got him into the suitcase and was all fun and games. And then as he is trying to get out, she committed forcible felonies to prevent him from doing so, leading to his death as he was begging for his life. And that's depraved indifference murder. It's like, yes. Yeah, it pretty much is. And so it's like, yeah, take your pick of which of the theories of the case you like best. Is it felony murder? Is it death in furtherance of a felony? Is it depraved indifference murder? Is it intentional murder? It's like, which of these theories do you like best? And the defense and the prosecution's like, okay, let me tell you which of the theories I like best. The theory that I like best is depraved indifference murder. Okay? With a depraved mind, with active knowledge, right? Knowledge makes it depraved, right? With knowledge that she was creating harm, with knowledge that she was causing issues, and with a desire to choose not to care. So basically, we're arguing knowing, if we want to go in our classic hierarchy, right? So we've gone from negligence to reckless to knowing, basically. So we're arguing knowing. She knew because she was being told, and she didn't care. And she tried to forcibly prevent him and all the rest of it. And that's our theory of the case. And that's depraved indifference murder. I'm like, it sure is. And then, if she tries to argue this is overt act, we're going to be like, no, the fuck it's not. And you can't argue that because it doesn't make any sense. I'm kind of with the state on this one. It doesn't make any sense. So she's going to get on the stand and she's going to say all these things because she's told us our theory of the case. Because again, it's an affirmative defense. So they have to let us know what they're going to be arguing. And we're like, that's some bullshit. She can't argue that. And I'm with the state. I'm like, yeah, she can't argue that. And I'm like, okay, well, she's just guilty of murder then. She's just guilty of murder. She doesn't have any valid defenses. It's all a bunch of bullshit. And it's like, yeah. So it's like the state just gave you your bill of particulars. Here's your bill of particulars as he unzips his fly and just lays down his dick right on the podium. And it's like, yeah, there it is. It's ready to go, baby. It's like, yep, sure is. You tell him, ma'am.
New statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Nice.
Any rebuttal?
I wanted that in writing weeks ago.
Oh, fuck you.
She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's expert. The characterization.
I wanted it weeks ago. How was I supposed to know that's what they're going to be arguing?
Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Werner, 5 of us there. Dr. Werner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment.
Well, that's a fuck up by you
Because I
then,
can't
isn't it?
testify to what she said. The 2 prosecutors can't testify to what she said. The only 2 people that can testify to what she said is Dr. Werner and Sarah Boone.
Yeah, then that's a fuck up by you.
We dispute their characterization of what she said.
I bet you do. I bet you dispute it.
That's just going to have to be testified to by Sarah Boone and then Dr. Werner.
Yeah. Ding, 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 ding. If you want to dispute it, if you want to dance, then get on the stand and tell us all about what was really said. I'm sure we look forward to that. I'm sure we all look really super forward to you clarifying about what was really said at the meeting.
Jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. It was something I was asking for a couple of weeks ago.
Shut up.
Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraph 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the costs of expedited transcripts. And I just want to make sure they meant to overrule that request.
I apologize because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents, the deputies that went out on the call-outs and the cases that resulted in cases to the state attorney's office and 911 dispatchers.
Okay. Is that accurate, Mr. Owens? That October 3 state's list?
But yeah, we don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Okay.
Judge, again, I'm not complaining.
Yes, you are.
Been on the case 45 days.
That's the biggest lie I've ever heard in my life. We're not complaining? Holy shit. Okay.
As we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose it. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, you know, Sarah Boone has a right to trial. Sarah Boone has a right to testify. Sarah Boone has a right to appeal. I believe those are the three
You
fundamentals.
absolutely have all those rights. You absolutely do.
Makes the decision about which witness.
Yes, you are absolutely correct. You are 100%. Sarah Boone has the right to decide whether to plead guilty or not. She has the right to decide whether to appeal or not. She has the right to decide whether to take the stand or not. You're right. These are decisions for the defendant and the defendant alone. Not much else. You are correct.
she may want some witnesses. She's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them.
That's true.
We may not call many of those that she wants to, but I believe my right to do that and to.
Yeah, he's 100% correct. He's 100% correct. He is 100% correct. The lawyer's job, the client sets the goal, the lawyer sets the means. That is just generally true in law, right? It's like you're hiring a professional to do a job. Really, this is fundamentally true for any professional for any job, right? You just hire the professional to do the job, and the professional decides how to go about it. This is true for any job. If you hire a guy to fix your car, you like go in and like, oh, my brakes are squealing, or I'm hearing a squealing noise. Can you fix the squealing noise? And it's up to the professional to choose to go about that, and what choices they make. And this is true for a lawyer as well. So the client gets some fundamental rights because, of course, the Constitution. In a criminal case, in a civil case, maybe less so. But you get the fundamental right to choose whether to plead guilty or not. You get the fundamental right to choose whether or not to take the stand or not. You get the fundamental right to choose whether to appeal or not, because those are all constitutional guarantees. And beyond that, everything else is left for the lawyer. The lawyer gets to choose what witnesses to call or not, what theory of the case to argue or not. They get those choices. And so the defense is basically now illustrating, or basically just saying that this is true. It's like, yes, we've noticed certain witnesses, I may not call them. In other words, I probably am not going to do what my client wants me to do, which is his prerogative. It's his prerogative. It's like he's the professional. He has the right to make those decisions. He has the obligation to try. Her interest apparently is, I'd like to be found not guilty very much. That is apparently the goal. I'd like to be found not guilty very much. And although that goal is impossible, he's going to certainly try. And it's up to him to try to figure out how to execute that objective. And he can't do it. There's no fucking way. But it's his job to try to figure out how to do the impossible. And however he chooses to go about the impossible is for his decision. And so I think it's just funny to me, because he's just letting Sarah Boone basically know at this point, it's not going to go the way you think it's going to go. I've also possibly because, it would be very interesting if the defense basically switches at the last second and goes back to accident, because up until the moment that, it's up to them to present their theory of the case, and they can choose whichever theory of the case they want. So it would be a very interesting moment if, when we finally get to it, the defense gets up during opening argument and be like, this was just a tragic accident, which they could do. They can change their theory of the case. The prosecution, incidentally, can do the same thing. They can change their theory of the case from the available evidence. We'll see. Maybe he'll chicken out. Maybe he'll chicken out at the last moment. He'll be like, you know what? That self-defense theory sounds like some bullshit. Yeah.
Our defense with our witnesses is paramount, and she does not have the right.
Okay, thank you. All right, court's going to take a brief recess to address this, and the Richardson violations will be in a short recess. Thank you.
All right, so we'll go back to live, and we'll just wait on the court to court. So we can hang out for a while we're waiting on the court to court. All right, questions, Q&A, thoughts, comments, considerations. So basically, long story short, the defense continues to take L's. They're not allowed to offer a lot of their evidence because it wasn't presented correctly, and they're about to have a Richardson hearing and about to be spanked some more. The state finally, you want a bill of particulars? Here's our bill of particulars. Here's our theory of the case. Basically, it's like, we'll give you our opening now. I wanted this weeks ago in writing. Okay. Can I recap the outcomes as a separate video? Maybe. Sarah is writing, Your Honor, I've been telling this, my cousin Vinny wannabe, but I want to take a plea, but he's not listening. Yeah. No, she was offered the plea in open court. That was the whole point. She was offered the plea in open court. So it's like, she can't say, I really wanted to take the plea. She was offered it in open court. Just to like, yeah. What exactly is a Richardson hearing? It sounds like a discovery violation hearing. Based on context, it sounds like the defense has not been providing exactly what they're supposed to be providing, and we would like some hearing on issues relating to discovery violations. It would also be interesting, of course, if Sarah Boone tried to fire her lawyers. I don't know whether or not the judge would allow her to do that at this point, to be honest. Yeah, offering it an open court was absolutely a high IQ move. It's like, I've never seen that before. I've never seen a plea deal offered in open court like that before. But yeah, it certainly prevents the, well, I want to take the plea deal. It's like, no, you were offered it in open court. So yeah. Tony P, thank you for helping to shill a little bit. I do love you guys. I do love you very much. And memberships on my channel are as cheap as YouTube allows them to be. We literally have the cheapest memberships of any channel because YouTube will not let them be any lower. It's 99 cents a month to be a member of this channel. 99 cents a month to become an uncivilian. You get your name in green. You get some scales by your name. You get access to behind the scenes content like editing streams and recording streams and gaming streams and stuff like that. You get some emojis. It's a good deal, man. Plus you get support on Civil. Plus at the moment you help to fund his purchase of a new XLR interface because I think I need one. And so I'm debating between the Focusrite Solo 4th gen, because I have the 3rd gen now. So I'm debating between getting the 4th gen versus the Elgato Wave XLR mixer. Both are $140. So, first of all, if you'd like to donate $140, that'd be really helpful. Second of all, I'm not sure which of the two to get. Probably will get the XLR one just because it has a capacitive touch mute button, which would be nice. It has a little button you can just touch on the top to mute the audio, which is a really nice thing to have. So I might get it just for that. So please donate $140 on Civil. Yeah, the Elgato Wave XLR if you have any questions. Do you like it? Do you like it? The instant mute is a nice thing to have. Yeah, and the lights turn on the device when it's muted. Yeah, that's nice. So the fact that I have a button that I can just touch to mute the microphone would be nice if I have to like snort or something, because it's just easier to just touch a button and mute the microphone so that, it'll be easier and better for your audio. So, yeah. I think I'll get the XLR. Thank you, Earth Fox Doll, for $15. I appreciate that. And I can get that on Tuesday so that we can have that for next week. Or I could theoretically go out and buy one. I would assume I could go out and buy one at like Best Buy or something like that. I might actually just go to a store and buy one. How about that? Instead of getting one on Amazon for a change, just go to a store and buy one. There's a Best Buy not too far from me. Do I think Sarah Boone is writing a level? The touch mute feature does a system level mute. Okay. What's the current model and name of my mic? My microphone is the Shure SM7B, and my current interface is the Focusrite Solo 3rd gen.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
William J.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
All right, Ms. Boone is seated at counsel's table wearing the same clothing from earlier this morning. All right, it is 11:24. With regard to the Richardson hearing with regard to item 6 in the defendant's fifth amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was cured by agreement.
You can assemble, yeah.
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 is the 119 new JPEG pages, reporting to be from Winter Park Advent Health, and they're a little bit
Let's see if this mute button actually works. Let me know if it works.
Okay. So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence. Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health
Excellent.
records, the 119 that we gave him this morning.
That is correct, sir.
So I do have a mute
With
mic
regard
button.
to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses.
I forgot I had
The
the
defense
mute,
shall pay
the mute
for
mic
any and all
button.
expedited transcripts.
All right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
State response.
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we've got a substitute analyst. So that's our reason for the late disclosure on her. And who were the other 2?
Rochelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts. And what I would expect will not be lengthy nor expensive.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cacciatore does not believe that the defendant ever deposed that person.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have the thing again, please? If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that Jury Services has told us the juror in seat 25 wearing badge 63 called sick child. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any.
For cause.
So stipulated, juror number 25 wearing badge 63 will be struck for cause. We'll advise the Jury Services to call them and tell them they do not need to report. With regard to the order tennis motion as to Ms. Boone's request for snacks, the order tennis motion is denied. Ms. Boone is being provided all the same services as...
No! Oh, no! Oh, the motion for snacks was denied. Oh, that's a tragedy, a travesty. What about the 8th Amendment, man? The 8th Amendment guarantees snacks. Worst court decision ever. 0 out of 10. 0 out of 10 court decision. Immediate appeal. Immediate appeal. We need snacks. Damn it.
As to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23
That's some
at
bullshit.
1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record.
Ah, that's some bullshit. Oh, man. Well, the motion for snacks has been denied. That is some absolute bullshit, man. 100% bullshit. Yeah. Yeah. RIP snacks. Yeah, 100%. 100%. RIP snacks. 100%. So she doesn't get her peppermints. She doesn't get her other things. Very, very disappointing. Yeah. She, I want some pizza rolls. That's what I want. I'm a motion for pizza rolls. Tostino pizza rolls. Or bagel bites. Pizza in the morning, pizza in the... let's see. Pizza in the morning, pizza in the evening, pizza at supper time. When you put pizza on a bagel, you can have pizza anytime. Pizza in the morning, pizza in the evening, pizza at supper time. When you put pizza on a bagel, you can have pizza anytime. Yeah, so I feel, or some Doritos, or a Snickers at least, man. A Snickers at least, because you're not yourself when you don't have a Snickers. This is some bullshit. This is some bullshit. She should absolutely have snacks. I can't believe the motion for snacks was denied. My heart is broken. I'm going to write a law review. About the Eighth Amendment implications of snacks. I'm going to call the ACLU, man. It's going to be great. All right. Yeah. So I guess that will end our stream today. And there is the prosecution, at least, is alluding to the possibility that we might actually have opening arguments today, which would be pretty amazing if they can actually get it done. So I don't know, but we'll tune in for that if it happens. Otherwise, I'm not going to watch jury selection, because watching jury selection is like watching paint dry. There's nothing to be gained or learned by watching jury selection. It's just watching paint dry. But I'll definitely tune in for opening arguments whenever that is. And yeah, why were snacks denied? Apparently, the judge ruled in his capricious Machiavellian way that Sarah Boone is merely entitled to the same food as any other person in the jail. How very dare he? How very dare he? Sarah Boone can only get the food that other people in jail are provided. And so she will be fed, in the same manner as anyone else, and no special snacks. What a disaster. What a disaster of a ruling. Man, good times. Is chili on garlic mashed potatoes still being considered? That'd actually be pretty good as a Cooking with Kurt episode. I'm feeling that. So next time I make chili, I could make some mashed potatoes to go with the chili. And then we could serve it on some garlic mashed potatoes on top of it. That could be fun. Can the lawyers bring snacks? I don't know. I don't know how that works. If they're allowed to slip or something in the court. I don't know. I don't know how that works. No pouch applesauce. I know. No pouch applesauce. No peppermints. She wanted exactly 5 peppermints, which is my personal favorite detail of the whole thing. Right? It's not that she wanted a box of peppermints. It's not that she wanted a bag of peppermints. It's not that she wanted peppermints. She wanted exactly 5 peppermints. That is my personal favorite detail. Why 5? Why not 4? Why not 6? Why exactly 5 peppermints? But she doesn't get any peppermints. No peppermint patty for you. No peppermint patty for you. Very unfair. Very cruel. Cruel and unusual. Cruel and unusual, being deprived of snacks. Yeah, I know. The conviction will be overturned because of that. That is a fundamental error. That is a fundamental due process cruelty ruling. Any conviction will be overruled because of the denial of snacks. It is a fundamental structural flaw in the court's ruling. I know. I agree. 100%. 100%. Did I watch the Menendez thing? No, I did not. I have not been following the Menendez thing. And I do not have enough information to offer an intelligent opinion about the Menendez thing. I do not have enough information to offer an intelligent opinion. So, yeah. PBJ is cruel and unusual. Lack of PB and J is cruel and unusual, if you ask me. But, yeah. What would I do for a Klondike bar? I know. Apparently, yeah, exactly. What would you do for a Klondike bar? Plead guilty, we'll give you a Klondike bar. Yeah. We're getting close to the actual trial. I know. I'm very excited too. 100%. We're getting close to the trial. I'm very, very excited. And then we can listen to the state roll out this horror show of a case. This is not food court. Yeah, apparently not. Apparently it's not the food court. That's sad. That is sad. It should be the food court. Could you imagine we have trials in the food court and then maybe the different stations are like the jury? That'd be good. 1 vote for Sbarro's, 1 vote for Chipotle, 1 vote for McDonald's. Who do you want on your jury? Which of the courts do you want on your jury? 1 vote for Panda Express. Got to have Panda Express in there. That's key. Which food court station do you want as a judge in your case? I will now accept your suggestions about which food court is best juror. Judge Whopper in the food court because you get to have it your way. Neat. Chick-fil-A. Respect. Respect. A little bit more of a conservative vote. Nice. Chipotle, 100%. Orange Julius. I don't know about Orange Julius. I'm not really feeling that. If you want to do an Auntie Anne's, though, I'll be down for some of those pretzels. That'll be fine. Cinnabon, maybe. Is Cinnabon too much? I think Cinnabon might be too much. Yeah, I think Auntie Anne's with the pretzels is the way to go. TCBY has to be Denny's. I've never seen a Denny's in a food court. I'm not sure if there is a Denny's in a food court, but if there is a Denny's in a food court, then sure, we can have Denny's. And they can ask all the questions. Absolutely, 100%. Yeah. As an Aussie, I don't have a clue about any of these, but I like pandas. Well, what fast food do you guys have? What do you guys have shopping malls? I imagine you do in Australia. What do you have for food in your shopping malls in Australia? What kind of options do you have in Australia? I don't know. What are your food court options over there? Dippin' Dots, Waffle House. Again, I'm not sure that I've ever seen a Waffle House in a food court, but that would be awesome. It's not fair, Snackless Sarah. I 100% agree, Snackless Sarah. It is 100% not fair. Thank you for the £5. Thank you for the £5. I appreciate them. Thank you. Panda Express is trash. Their honey walnut shrimp is pretty good, I have to say. So I am a bit of a fan of the honey walnut shrimp. So if you haven't had it, I'd give it a shot. Hot dog on a stick, 100%. Burger King is Hungry Jack in Australia. I think I remember that. Yes, I think I remember that. In-N-Out Burger in California, 100%. I'm down for In-N-Out. Sbarro's, of course, Sbarro's. Got to have Sbarro's. 100%. You've got to have Sbarro's. Is it even a mall food court if it doesn't have Sbarro's? Is it even really a mall food court if it doesn't have Sbarro's? For the benefit of our Australian neighbors, Sbarro's is a pizza chain, and their pizza is not really very good. That being the case, however, they are somewhat ubiquitous at United States food courts. So they're ostensibly a pizza place, but not a very good one. But they exist in every mall, everywhere. New York fries, yeah. Musabi Cafe, but I think it's only Big Hawaiian Mall in Honolulu. Ooh, I'm up for some Hawaiian. I'm up for some Hawaiian flair. We can do a luau right in the food court. We'll get some lays. It'll be great. Yeah, I'm down for some Hawaiian. We'll do a pig roast. That'd be fun. Or we definitely need to have a Donner Bistro though. We need to have some sliced meat. We need to definitely have sliced right off the pit Donner, German style. 100%. So that we need to have that. Yeah, Sbarro's is the food courts where Hunt Brothers is the gas stations. Kind of, sort of, yes. Although Hunt's Brothers is not as good as Sbarro's, and that's saying something. But your point is taken. Hibachi Grill, nice. Australia has election sausages. Okay, I don't know what that is. Doner kebab, yeah, 100% doner kebab, yeah. We definitely need a doner kebab. I love doner kebab. We definitely need to have a doner kebab. Yeah, sliced straight off the pit, 100%. Baba tea is some bullshit. Yeah, bubble tea and baba tea is some trendy bullshit that needs to die. You never heard of doner kebab? You definitely got to get it. It's great. They have meat right on a spit, right? And it rotates and it cooks and they slice it right off the spit. Fantastic. There should be a doner kebab everywhere. They're the best thing ever invented. They're the greatest. And without them, we would all be lost. The only good baba is the one with liquid inside. I don't want to chew my drink. I don't like the liquid inside either. I don't like that sensation of like the bursting thing. I don't like that, man. Doner kebab shops everywhere in England. This is why England is awesome, because they have doner kebabs everywhere. Doner kebabs are one of man's greatest inventions. And there aren't enough of them in the United States. You can find them in the United States, and somewhat increasingly so, to be honest. But there aren't enough of them. There needs to be more. There needs to be more of them. They are awesome. Doner kebabs are life-giving food after a night out in Scotland. I hear you. At my old apartment complex, there was a kind of doner place, food truck, and they did a half-decent job, but it was really near my apartment. And so I used to get it like all the time. It was great. I miss it. Yeah. Doner kebab is basically shawarma. Yeah. It's basically the same thing. Yeah. It's basically the same thing. Okay. Well, I think that will end our stream unless there's something else for us to discuss. England is terrible overall, though. England is not exactly known for its food. So there's that. I think we'll end the stream for now. Let's see where I can send you. Let's see. Carrie Saturs Productions. I'm not sure what they're doing over there, but I'll send you that way. They've been nice to me recently. They've been nice to me in their chat recently, so I'll send you over their way. KFC is pretty good. I do like KFC. Yeah. I don't even think I can send you EDB. I don't think she allows redirects like that. I don't think she allows redirects. So I can't send you to EDB. Doner kebab, doner Turkish. Doner or doner kebab is a dish of Turkish origin made of meat cooked on a vertical rotisserie. 100%. Well, I do appreciate all the other piggy banks. I do appreciate you guys sending money and support wherever you guys send it. Crazy Cat Queen, that's very nice of you. Thank you. Do I like Mexican food? Very much. I had some nice tacos yesterday that were very nice. And a nice little quesadilla. That was very nice. Hello, Germany. I do like Germany. Deutschland. Does KFC still have Peach Mountain Dew? Not to the best of my knowledge, but that'd be an interesting thing to try. All right. Well, if opening arguments happen today, then we'll be back for them. And whenever this trial starts full steam, we'll be here for round the clock coverage. So we might miss the start of opening arguments depending on what they happen, if they happen at like an unexpected time or I miss it. But other than that, we're going to be watching this trial every step of the way, because this trial is just fascinating to me. This trial is absolutely fascinating to me. Thank you very much, Crazy Cat Queen. I do appreciate your donation. That's very kind of you. All right, I'm going to sign off for now. When you go to the other channel from the redirect, be nice, be courteous, be supportive. You know the drill. Be a good representative of the channel. Be nice, obey their chat rules and all the rest of it. And be supportive. And I will see you back. If there's more hearing, I will see you back. And more likely, I will see you back for whenever our opening argument is. And if that's today, then that's cool. And if not, then that's also cool. So I will see you for back whenever that is. It'll be fun. All right. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers for now, my friends.